Okay. Um, Good evening, everyone. I'm Harshita. I work at Daksh, and we welcome you to this session on behalf of Judicial Data Collaborative, GDC. It is with great pleasure that we are all here today to celebrate the launch of the Justice Definitions Wiki page, a groundbreaking initiative aimed at bridging the gap between legal theory and practical application. The Justice Definitions project goes beyond the conventional boundaries of legal concepts through a collaborative approach. This initiative finds its roots in the Judicial Data Collaborative (JDC), which was convened by Daksh along with other civil society organizations, lawyers, and experts in the field who are interested in accessibility, quality, and reliability of judicial data in India. This wiki page it delves into the functional understanding of legal concepts by stakeholders within the justice system, how they are counted by government agencies, and the comprehensive review of these concepts by official commissions over time. Additionally, it takes into account the regional nuances that vary across Indian states, shedding light on the broader implications of our justice system. So, this session will begin with a presentation by my colleagues Bhavya Sudhir and Smita Mat, who will present an overview of the Wiki project. And before we go in there, this is for all the people who are watching. Feel free to drop your questions on YouTube comment section. We'll track those. And towards the end of the session, we'll ensure to address them all. Thank you. Smita and Bhavya, you can take over.
Hi, I hope I'm audible.
Yeah, I think you are.
Okay,
Go
so
ahead, Bhavya.
yeah, so hello everyone, I'm Bhavya. I'll be presenting to you the concept of our judicial data wiki. And
Yeah, I think you are.
okay, concept of our data wiki.
Go
So
ahead, Bhavya.
yeah, so hello everyone. Okay, so I think it's some echo issue is coming up, but now it's sorted. Okay, so I'll be presenting to you the concept of our project and the work undertaken by our community over the last few months in developing this project. My colleague Smita will then cover the platform layout and features of the project. The Justice Definition project is our endeavor to co-create wiki database to unravel intricate web of legal terms and concepts. uh, the Justice Definition project of the Judicial Data Collaborative seeks to co-create a wiki database and unravel the intricate web of legal terms and concepts. The Justice Definition project or the Judicial Wiki for Definition and Taxonomies is hosted on a media wiki platform and would facilitate interconnected understanding of legal terms, tracks the development and evolution of the concept, demonstrate how judicial data is captured and publicly released, and unpacks variations in procedures across the justice system, essentially through collating information about these physics. Smita, next slide. So we have been able to uncover variations and linkages between the official literature, public database, and existing research. The definition terms not only seek to deliver a holistic understanding of the terms, but also help in identifying the underlying issues and challenges in terms of their conceptualization, application, and data presentation. This wiki in this way offers a platform to deliberate on the issues and challenges faced and offers an opportunity to suggest actionable solutions. The next slide, Smita. Uh, Actionable solutions can be by way of discussion and agreeing on them by surveying the official data, by connecting with official data creators, and by empowering the data community for focus on the interoperability of the system. Uh, that is why we seek to invite stakeholders from diverse disciplines and backgrounds, including technicians, public policy professionals, data data researchers, academicians, and other such stakeholders which are interested in the judicial data. Next slide, Smita. And by collaborating and collecting all these facets of collating information, deliberating on issues and challenges, and suggesting actionable solution, the objective of the wiki, which is to engage with the judicial data and suggest actionable solutions, gets fulfilled. Um, how are we do how are we able to do it is through the structure of definitions that we have agreed upon. Any ideal definition has multiple facets. It includes a general understanding of the concept. Then we also survey the official definitions of the term. For this, we survey the legislations, the government reports, and other such documents which describe that particular term, and then identify the variations that are there and how that can be bridged, or uh, and the reasons behind such variations. Types, components, kinds of terms also tells us about the classification of major categories that is there. This essentially builds up the official definition part, and in cases where there is variation, so this particular facet kinds of covers that thing. International experience gives us an opportunity to look at the best practices and seek, compare it, and look for comparative viewpoint, which is very important for the evolution and suggest changes and to suggest changes. Appearance in database is a very unique feature of this wiki project, because this is something that is not usually found in the data source available uh, online. Uh, in the database section, we actually survey the databases like National Judicial Data Grid, eCourts Project, Crime in India website, and other such databases where information and data relating to judicial data is collected. Research that engages with part is another facet in which we are essentially collating the research reports, research papers, and other documents that are related to the term, and uh, seek to, and this actually offers us an uh, opportunity to actually explore how uh, what has been deliberated upon these issues, what are other stakeholders, civil society organization, academics are talking about. So we get a sense of what's the discourse around that particular term in terms of policy reforms and other such things. Challenges and way ahead, again, is something that is a facet that is an extension of the deliberation that goes after the collating process, and this seeks to improve. This would improve in times to come and is a ever going process. So ideally, as you can see, the ideal definition term, the structure covers all the facets that are necessary for the to track the evolution of the term and how it's going to be, and suggest actionable changes. Smita, we can move to the next slide. So now, for the past few months, we have been working on this project. Uh, it started with setting up the definition project on a wiki platform, which was in itself a very big call, because we had to decide whether uh, how the information will be collated, how the community will be engaged, and we came to this consensus that wiki would offer us that kind of a platform where we can engage with the community and serve our ultimate objective of co-creation of collaborative knowledge and sharing. Building community is another aspect. Like I said earlier also, that there are other, we seek to uh, engage people from diverse disciplines. That's why while building community, we keep that as a important consideration, so that people from diverse background, including technologists, data researchers, and other such people who are interested in judicial data, are involved in this particular project. Uh, the third phase, as you can see, the first phase of Student Research Associate program, which we have been continuing till now, and it has really yielded very good results because the students have actually worked very hard to meticulously compile information and give the first like the bag to cover all the background information, collating it on a particular document, going through a review process, making edits, first draft, second draft. The whole process was very extensive, and students have been engaged in this whole thing. And that's why we have come up, that's how we have come up with very extensive definitions uh, till now. So as you can see, till now we have covered around 60 definition terms. Students have worked on these terms, and after working on them, it goes through a review process, they make edits till the time, and then they finally upload it. Now these particular terms which are on the wiki will go through another process of review, that is for the community to do, for the public to do, as we upload them on the wiki. Smita, next slide.
So thank you so
So
much, Bhavya. I'll take over from here. So yeah, as Bhavya was saying, we've been working on this for the better part of the last year. I want to say it's been a project that's kind of brought in, it's truly been a collaborative experience for us and brought in a lot of kind of new and different partners in the process. And this is something I think we'll talk about a little bit more. But currently, as of today, this day that we're launching, our wiki has, well, it says 578 edits, but I think we were just doing a bunch of edits just before this. So I'm sure we would have crossed 600 at this current point, across 48 definitions that are currently uploaded onto the wiki and have been created by 21 verified users. So there are two parts of the project as well. One thing that Bhavya talked about was the definitions themselves. So taking a single concept or a term and then kind of building out the whole page that goes into these many dimensions, perspectives, sources, connects, links, does all of these things. What we are also kind of doing on for each definition in each page is similar to the way that Wikipedia does it. Each definition can be categorized into different categories, and it can be found kind of within those lines to kind of build up a taxonomy of the terms themselves. So we have two levels in which we're doing the classification to build this taxonomy of the definitions. One is the associated institution. So the definitions that we've taken, they are ones that come from courts, they're ones that come from kind of the way that the police engage and how they work, as well as prisons. So a number of our definitions also, they don't have to just be only one institution kind of, we're looking at how many tags are relevant and necessary kind of in putting these together. So say a bail would be both a term and a definition that would come in, that would be related to courts as well as be related to prisons. And at the same time, we're kind of looking at what the attribute or the type of the term is. So say, is it a person? Is it a process? Is it a document? Again, it can be both a process and a document. But is it, say, infrastructure, physical infrastructure? Is it some kind of specialized institution, like a consumer court or a family court? Is it maybe a type of or an attribute of data? Say, is it a case type or something that's kind of an attribute of the way that that data is captured within the system as a whole? Is it a digital system or some kind of digital transformation initiative? So say something like virtual courts, paperless courts, we would be tagging all of those definitions towards digital transformation or digital system. And at the same time, is it a legal principle or a concept? And this is something that as more students and again, working with academics, as I'm sure Professor Ankit will speak about a little bit more, some of the terms that have come in are things like natural justice and are things like burden of proof. So I think are a reasonable standard. Yeah, so I think some of this is our sense of the umbrella and the breadth of the wiki as it exists right now. But these term by term categories can be added, categories can be kind of merged as they go on. Kind of the community itself can take a call on what this would look like and what the taxonomy of the wiki, the backbone and the structure of the wiki would actually be. I'm going to quickly just talk, the JDC has this definitions project is one of the first projects that we're launching under the Judicial Data Collaborative. But another project is very similar to the definitions project, which is our ontology initiative. If this is something that's interesting to you, I would highly encourage you to go to the Judicial Data Collaborative's website and take a quick look at the Alliance for the Development of an Indian Ontology. And so what the ontology project does is it works from more of a technical manner to take a corpus of documents, of judgments, of databases that are available and identify concepts from more of a technical text analysis process and map their relationships within specialized legal domains. Whereas this wiki is much more of a human, a community created, I think we're thinking of it as a knowledge hub almost, to take different dimensions of these concepts, put them together, and kind of have a place where the explanation of a concept that you might find in a legal textbook can live alongside how, say, NCRB counts it, can live alongside what, say, academics or a think tank might have written about it, engaged, kind of delved in over time, and how the idea of the concept itself has changed. So in terms of the project itself and the way that we're thinking about it and how it's moving forward. So we've put together an editorial committee now that we are out of this first building phase and we're looking at more of a growth phase. So we're going to be working together to guide the project and to kind of figure out how we can, as it opens up a little more, maintain quality and accuracy now that each definition wouldn't be checked according to the way that Bhavya has mentioned that we've been using so far. So what kind of processes, what kind of mechanisms we need to put in place going forward. And in the next few months and in the next phase, I think we're really excited to see how this comes about. But identifying both individual and institutional collaborators that can help, not just in literal kind of contribution writing on the wiki, but also as more cohorts of research associates come in. I think one of the most successful elements of the research associate model that we've had is where the RAs will kind of work on one cut, pull together existing things that they found, and then speak to people in the field, speak to practitioners, speak to people at kind of the organizations that we represent and work with, and kind of get certain insights, feedback, ideas that they can then work on, flesh out, add to the page. And so truly this will kind of go on to be a collection of working knowledge as well as things that are easy to Google, find online, find in textbooks. And as we move forward, I think one of the things we also want to do is have a sense of what priority areas we should kind of get into and work on in depth as well as in breadth. And so again, finding ways that institutional collaborators, experts in a particular area can kind of share the knowledge that they've gained in terms of understanding how certain processes work, or even accessing and being able to work with data as it exists, with reports as they exist, what's tracked and not tracked, and kind of putting some of these things, not just in terms of what's available, but also, as Bhavya mentioned earlier, the gaps, the challenges, and things that I think there's some sense that maybe something can or should change about the way we think about it, and kind of using this as a platform to have those conversations. So we, again, I'll wrap this up, but we are extremely excited to kind of see how this moves forward. We're looking for students, researchers, someone who's kind of a data or a technology person, legal practitioners, organizations as well, to kind of come together and work with us to build a shared, substantive, deeply nuanced, but also data informed, given the amount of empirical work that's taken off in this space, understanding of concepts across the justice system and the justice space. So we have a Google form. I think we'll share it in the link of this YouTube video, but it'll also be available on the wiki and the web page. Please reach out to us and kind of let us know in two ways that if you would be interested in working. One is even just suggesting certain terms that you think it might be interesting or worth having a deep definition kind of worked on and put together. And second is if you yourself would be interested in kind of having one of us can work with you to set up a registered user account. And we have some resources on the wiki. We'd love to kind of have you come in, write, build, edit, modify, work on it with us as we go forward. So this is something that Bhavya and I have put together to kind of just give an idea of the project itself. My screen is still sharing, is that right?
Yes, yes.
Yeah. Okay. So then I consider myself extremely privileged to be able to share what we've been working on, so many of us, for so many months. This is the Judicial Data Collaborative website, which is one place where you can kind of come to find a way to get to the wiki. Additionally, yeah, so the URL is jdc-definitions.wikibase.wiki. So you can find it kind of straight from the URL as well. This is the wiki that we've kind of set up. Again, as we said, 3 aligned objectives. Within this, we've created, as Bhavya mentioned, an idea of a common format that can guide kind of the way that terms are being kind of created and put together. We've also kind of created a short editing guide, both as a video and as a document that can kind of help. And then what I'll do probably at the beginning is I'll very quickly just show, I think, a couple. Let me start with case clearance rate, because this is something that, so one of the research associates, I believe Saday, who worked with us on case clearance rate, and this is one where he was in touch with and worked with the team at India Justice Report to kind of add certain dimensions of it. So starting out, as Navya said, just the basic idea of what it is, what an official definition might look like, and how this is actually put out by the official data creators across different high courts or different courts. Yeah, the union budget, again, the definition that's been put forward there, the different types of case clearance rates. So again, if there are certain variations or certain slightly different ways in which it's used, any official database that would kind of use this concept, count this concept, or measure something relating to it. I think we've been very clear to have as many links as possible, as many interconnections as possible, and as many images of listing things as possible. And then coming down to kind of research that we know of thus far that engages with the concept and how they have. So this is a section, again, that as more people kind of come in, we would love to see these sections expand, become more deep and nuanced. And so this is, again, a small snippet from the India Justice Report that outlines the methodology they use as a report to actually calculate and assess. And again, so again, the European Commission for Efficiency of Justice and how they have engaged with the idea of case clearance rate. And again, how this has varied across different documents, what formulae have actually been used, and the challenges and the way ahead. So this reference section is here as well. The standard thing about Wikipedia, I think, would probably apply here, which is even if you have questions about the veracity and the accuracy, even kind of coming to a definition, going down to the references and being able to have them in one place where you can move out to kind of different sources and different explanations. We believe that this is something that would be incredibly useful. And so case clearance rate has come under both courts and performance metrics as categories. So yeah, the same way that Wikipedia looks and works, kind of all of these concepts together in one place. I think case clearance rate, maybe there's another that I should kind of go into before handing over to some of our research associates who can take on as well. What shall I do? Let me do pendency. So this is another one where, because with pendency, I think the common parlance, the common usage of the term is not just, is kind of, it's either the duration of time that a case is pending, pendency, or it's the quantum of pending cases before courts. So with this definition, we've kind of gone into what pendency is and isn't indicative of. We've gone into how different law commission reports have defined not just pendency, but allied terms. We've gone into kind of the different time frames or methods of kind of evaluating recommended kind of, the different kind of, time frames that have been suggested on this. And again, the way that, say, NJDG and different annual reports quantify and put out information on pendency into the public domain. Certain reports, projects that have engaged with pendency as a concept. And then this is something where, I think taking a lot of the work that we do and taking the things that we have had to kind of assess while we work, kind of do our projects and do our reports, is I think we tend to calculate pendency from the point of view of calendar days and not working days. Whereas I think there's some discussion that we can and should be had about which is the better metric and which purpose it better serves, how to best describe pendency over time. And then what kinds of, so the idea that, again, with pendency, even if you're talking about quantum, what is a case? There are certain courts that wouldn't consider interlocutory applications or certain petition types as distinct cases, whereas others would. So what is maybe required on a data creation level to make it more of a comparable concept? So these are two definitions that I think I'm thrilled to have been able to share with you, but I'll now hand it back to Harshita. Thank you so much. And we'd love to hear from some of the students that have worked on this project with us.
Thank you, Smita and Bhavya. The entire presentation was very insightful, and thank you for taking us through the website so that people can know where to look, what to look for, and all the processes that was involved in this project. Okay, so as Nita said, now next we'll hear from our student RAs, that is Soumya, Sparsh, and Manas, who will now present their definitions and take us through their experience of this entire project. I think Soumya is starting. Soumya is going to begin. So over to you, Soumya.
Okay, hi everyone. I'm Soumya. I'm a fifth year law student from Gujarat National Law University, and I've been a part of the Definitions Project Student Research Associate Program since May 2023. The project has definitely stood out compared to my other research internships because of how practical the aim of our project is. And there was so much to do with the writing and the research, and even when we got to upload our term on the wiki, it was such a different experience. And I'm really thankful to everyone at Daksh for this opportunity. So throughout my term with Daksh, I've had the opportunity to work on quite a few different terms. So I've worked on notaries, interlocutory applications, case information systems, family courts, and court managers. And today I'll be sharing a few insights on court managers and family courts. So moving ahead, I'll start with court managers. So court managers is a post which was introduced in 2010 under the recommendations of the 13th Finance Commission, and there is no official definition per se. So if you look at the report, it just states that the post of a court manager would be created in each judicial district to assist the principal district judges in the administrative functioning of the courts. So this is a kind of vague definition, and I feel like this vagueness has translated into the current state of court managers, whose posts have still not been made a crucial part of the court administration. You can see this through the varying modes of appointment, the qualification requirements, and a lack of the regularization of the post of court managers. So starting with appointment of court managers itself, we can see that there are three different ways in which court managers are appointed. So several high courts have incorporated the post of court managers under the high court service rules itself. In other cases, high courts have made separate rules. And in the third cases, high court is still appointing court managers on a contractual basis. Moving on to the qualification requirements, the 13th Finance Commission report only required court managers to have an MBA, but the high courts have prescribed a wide variety of qualification requirements for them. So with regards to work experience, across states, it's a wide range of around 2 to 10 years of work experience that court managers are required to have. And some high courts have very niche requirements, such as the candidate must have a BTech along with an MBA to qualify for the post of a court manager. And then they prescribe skills such as computer application skills. Several states have prescribed the need to know the vernacular language of the state. So there are quite a lot of differences in the qualification requirements of court managers across states. Now, all this, it comes down to a few challenges, and the most important, the most pressing challenge is that the post of court managers has not been regularized in several states, and what this means that they are still not integrated into the court system. And by regularizing court managers, what we can do is we can ensure that they have a fulfilling career with growth prospects, and a regularized post will give them an incentive to spearhead the administrative changes for which the post was created for in the first place. And another requirement that is necessary is that the functions of court managers across high courts should be laid down more clearly, and they should adhere to the guidelines laid down by the 13th Finance Commission. If you look at a few of the functions that court managers have, they are required to ensure they have to comply with uh, adjudication standards, ensure that the court is user friendly, ensure that there's a proper management of court, and for our project especially, ensure that there are accurate statistics on the functioning of courts. And they should ensure that there's a smooth and efficient functioning of courts. So this is a few insights we had on court manager. Now moving to family courts, again, there is no definition in the Family Courts Act of 1984 regarding what a family court is, but the Department of Justice states that it's a specialized court which will exclusively deal with family matters so that such a court may have the necessary expertise to deal with these cases expeditiously. In family courts, we explored the judicial data that's available regarding family courts. And if you look at the Department of Justice website, there's a very easy to use dashboard on the state-wise data on the number of functional courts, number of cases disposed of during the month, and number of pending cases which is available. But we noticed that there is no such comprehensive database on district level data on the performance of family courts. So currently, the only way we can get a picture of how family courts are functioning across districts is by going through the e-courts website and manually taking out orders for different family court matters. So we do require a comprehensive district-wide database. So for example, the Madhya Pradesh High Court has a family courts website, which has very clear district-wide monthly data, family court cases disposed and pending, which are available for all to see. And similarly, states can look at initiatives such as the one very recently launched by Kerala High Court, which is a family court case management module, which provides a very effective case management system that has features such as case allocation calendar and dashboard for the High Court judges to monitor the case pendency in each family court. So these are a few of the insights I had on court manager and family court, and thank you so much.
Uh, Next, we have Spurs presenting. Spurs, are you online? Hi.
Thank you, ma'am. Good evening to everyone present here. My name is Pasha. I'm a third year law student who is currently studying at National University Odisha. I had the opportunity to work on the definitions project as a student research associate from June 2023. The definitions project gave me the opportunity to explore the meaning and functions of the most basic legal terms, which are often overlooked. The definitions project, under this project, I worked on three terms specifically, that is judge, bench, and ICJs. And all of these terms constitute the most basics of justice system. But when I worked on this project, I realized that a person who's engaging in these judicial data may face problems because there is not a lot of data that's there, that is easily available, that is easily understandable. So in this presentation, I will go over the terms that I worked on and offer a brief overview on the significant findings and the concept that I had challenges with. Starting off with the first term, judges, I explored its official definition, types of judges, challenges that we would face in terms of exploring the data, and also the research and literature on the terms. So the term judges is defined under section 19 of IPC, which talks about any person who is empowered by law to give definitive judgments. If you see the definition in the most simplest understanding, you realize that the definition aims to provide a very broad but very clear definition. The judges in India have a hierarchy according to the courts. So the appointment procedure as well as the qualifications of the judges are predetermined by constitution in cases of Supreme Court, and High Court. But this is not the case when we look at the district court. There are slight variations which cause complications when we are really researching and understanding the term. So the major differences or the major distinctive variations that I came across during the research on the district judiciary as well as the lower subordinate judges was, for example, in the case of appointment of the judges based on the quota or the research on the quota appointment, as well as the role of the Public Service Commission. For example, the Supreme Court, in the case of All India Judges Association, mandates the ratio of the quota to 25% to 10% to 65% from direct recruitment, department competitive exam, and the transfer recruitment, respectively, in cases of vacancy. However, in states like Andhra Pradesh, Assam, and many other states, they have slight variations and have the appointment based on the percentage ratio of 25%, 25%, and 50% instead. All these are varied according to the state rules as well as state laws. Similarly, the role of public service commissions in some states have them handling the entire procedure for district judges as well as lower subordinate judges. But in some states, the High Court also has a particular handles along with the Public Service Commission. So therefore, there's a certain variation which required a lot of research and a lot of dialing down and seeing the state laws and state rules, which had a lot of variations over the states. In case of the research that engages or the official database that I have worked on the judges, the government through its digitalization reforms has created various official databases for accessing records and judges at every level. For example, the Department of Justice website or the Supreme Court website. But there still is a gap in these data sets because they do not comprehensively capture every data that's available on judges. So to cover these gaps, there are many data sets like the COJ data set, which is Know Your High Court Judges data set, as well as the India Justice Report, which throws light on the judge to population ratio, the judicial vacancies, the gender and caste diversity. And the COJ data set, which is hosted by the Justice Hub, covers over 4,000 High Court judges and provides like an illustrative judge dashboard for the same. It throws light on the socio-economic profile of the judges, and it also explores the professional indicators that reflect the experience and expertise. Through this, when we're researching about judges, we understand how or where they came from, and it provides an easier material for us to make any kind of analysis on judges. The other research or scholarly articles that I have worked on in the judges wiki page is for example, schooling of judges by Rajiv, and also calculating judges' strength in India, a time-based weighted caseload approach by Daksh, which gives unique perspectives and also research on different aspects of the term judge itself. There are also other scholarly articles like by Upendra Bakshi, which really dwells into what the concept of judge is. The next term that I have worked on is the word bench. So the word bench has no official definition per se, but it has a lot of other meanings in different acts according to the term, according to the act that they are going towards. So bench in India is classified on the basis of territorial jurisdiction and strength. Under the strength-based benches, there are single judge bench, division bench, and constitution bench. In the Supreme Court, the single judge bench was recently added in 2019 through an amendment to the Supreme Court rules and has gained prominence due to the rising pendency of cases. The other two types of benches are the division bench and the constitution bench, which we have heard a lot over when we're talking about things like case pendency and also analyzing judges. The other important classification or the other classification of bench can be seen on the basis of territorial jurisdiction, which can be classified or understood under High Court or Supreme Court. For example, the idea of regional bench under Supreme Court has been debated in the recent years a lot, especially in law commission reports and other informal forums, where they want to constitute a regional bench to increase accessibility. So these form different benches in the Supreme Court that they aim to establish or are looking towards establishing. The other bench that is on the basis of territorial jurisdiction can be seen in permanent benches in High Court, which are basically benches that are established other than the permanent state. Therefore, there are various types of benches within India. And we can see the concept of benches also in international experiences. They have the most unique idea or the concept that I came across during the or while researching over international experience on bench was the en blanc concept. So the en blanc concept basically talks about setting up a bench of maximum strength to review appeals of smaller benches in cases of subjects of importance. So while we have the constitution bench here in India, which sits on a strength of 5 or more according to the importance of the subject matter, in en blanc cases, which is established in so many countries, here in blank cases, the judge strength is the maximum. That means in India, we have a strength of 33. So the entire bench of 33 would be sitting, which is not, that is something that we've heard about in India. So that was one of the concepts that I came across during researching international experiences. So so where can we see benches or where can we explore benches in official database are in the cause list or in the things that are put up by the Chief Justice. That is the roster for benches that is determined by the Chief Justice. In some high courts, the allocation of matters is further managed by automatic case allocation system, like in high courts of Allahabad, Bombay, etc., which allots a bench ID. As far as the research literature in the bench or the term bench, the research on this term is mostly centered around the declining trend of sitting constitutional benches in the current years. It mostly analyzes the data on the frequency of 5-judge benches for cases and the pendency of cases to the benches constitute. So the major data challenge that I mostly encountered for the term judge and bench is its multiple conceptions. So there is no particular set data that I could derive from, or a set website that I could derive from for all the information. And there's a lot of fragmentation of data, and also there's no data quality in the sense that which is accessible and is standardized for us to have a clear picture of what these terms speak about. The last term that I worked on was the ICJS. ICJS is basically the interoperable criminal justice system. So this is the most exciting and challenging term that I worked on, because this was something that was very new to me and I would not have discovered if I had not worked on the project. So this is a very latest technological development by the E-Committee of Supreme Court. What it aims is to connect different pillars of the justice system like prison and prosecution, as well as forensic and all these other pillars as well, and make it into an integrated system which helps or gives an easy access to all the platforms to the official person. It is being implemented in phases and it integrates CCTNS, that is for police, the e-prisons website, the e-prosecution, e-courts, and e-forensics. So basically, it tries to provide an integrated website where people from the official post can easily access and do a cross search and do not have to go through the hassles of having multiplicity of websites in which they have to search over to get a particular data. So the official database is not accessible to the public, and it is only accessible to the officials associated with the pillar. This is to ensure the protection of data site. So in the wiki page that is there on ICJS, all the information or the official database, how it works or how it looks, is derived from the user manuals that are published by the agencies that are in charge of these pillars. For example, the NCRB for police and NPIP for prisons and DFSS for forensics and the E-Committee itself. So working on ICJS was very challenging because it has limited data published and required a lot of research through government reports, user manual, data sets, etc. But researching on the term provided me an insight to the technological development of the government as a part of the digitalization to enable an accessible and integrated system for effective criminal system in India, which I otherwise would not have explored. The other way forward for ICGS is in fingerprints and as well as PBI integration, which explores the future of ICGS. So through this term, I would like to end the presentation, and I would also like to convey my gratitude and thankfulness for giving me the opportunity to work on this. Thank you so much.
Thank you, Sparsha. That was great. Next, we have Manas. He'll present on two terms, and he is from the RGNLU. Manas.
Is the PPT visible?
Yes.
Okay, great. Just a second. Hello everyone, I'm Manas. I'm from NLU Patiala, and I've been working as a student research associate on the project since May. And today I'll be briefly outlining three terms that I've worked on: plea bargain, convict, and criminal leave petition. Right. So to begin with plea bargain was actually introduced under Chapter 21A of CRPC and came into effect from 2006. The provisions are essentially a result of extensive deliberation which were taken up under 142nd Law Commission report. These recommendations were further affirmed by 154th and 177th Law Commission report, which would be the Malimat Committee report and the Parliamentary Standing Committee report on Home Affairs, which was chaired upon by Sushma Swaraj. So while working on the definition, I came across that there are generally three types of plea bargaining. One is charge bargaining, where what is agreed upon is essentially a reduced sentence or reduced charges. Second is sentence bargaining, where an alternative or a lighter sentence is agreed upon by the accuser and the prosecutor. The third is the fact bargaining, where certain facts are admitted upon by the accused, and certain facts are agreed upon by certain facts are not to be agreed upon in front of the court by the accused, right? When you look at international experiences regarding plea bargaining, what is very visible from just a preliminary research is that US and Canada use plea bargaining to a very extensively. It is ubiquitously present in the criminal justice system. Approximately 90% of all criminal cases are actually disposed through plea bargaining. Right. In India, however, there are certain restrictions on the application of plea bargaining. So, for example, it will not be applicable on offenses for which the prescribed punishment under the Act is of more than 7 years or is of death or of life imprisonment. It also won't be applicable on offenses where the offenses have been against women or against children below 14 years. The official data regarding plea bargaining can be found in Crime in India report, which is put together by NCRB, and it contains statistical information regarding court disposal of criminal cases. So it would contain categories such as crime against senior citizens, crimes against scheduled castes, economic offenses, etc. The data essentially shows that plea bargaining in India is used on a very minuscule level. And the reasons for that obviously not given in the report. However, research suggests that the reasons are multifaceted and are actually difficult to capture considering the fact that plea bargaining is a closed door process. But so far the research shows that the reasons for failure of plea bargaining in India has been that it has been applied very crudely. It has been a crude replication of an American model in the Indian framework, and it is not catered to the Indian socio-economic or cultural conditions. Secondly, there have been extreme regulations on its application as compared to US or in Canada. So, for example, we have a 3-party format or a 4-party format, which is happening under the watchful eyes of the court, which is very contrary to what is happening in US and Canada of a 2-party format. Moreover, we have more attractive alternatives other than plea bargaining that anyone would actually avail, right? So moving the high court for quashing of an FIR or termination of a case or even withdrawal of a case. So in all of these alternatives, the tag of conviction is actually removed from the accused. So very obviously, in order to avoid the stigma around conviction, anyone would actually go for these alternatives rather than plea bargaining. So this is it on plea bargaining. Moving on to convict. A convict is a rather simple and a general term. It doesn't really require a definite definition. CRPC itself does not define the term convict. However, it does contain certain provisions related to it, such as remission of sentence, commutation, or appeal upon conviction, or bail after that appeal, right? So, the a cogent definition of convict, however, can be found in Model Prison Manual or Prison Statistics in India report, right? So the essence of both the definitions that they provide is essentially an association of guilt of a criminal offense, which is done to the person by the verdict of court of law. Prison Statistics India report also contain information regarding the demography of convicts. So it would contain information regarding their age group, their education qualification, or domicile, etc. Another report that can be used to understand the milieu in which convicts are living is India Justice Report. It does not define convict, neither does it talk about convicts directly, but it does talk about prisons, which indirectly tells us the condition in which a convict would be living, right? So it would be bringing out, shedding light on problems such as overcrowding, occupancy issues, lack of education facilities, or poor mental health. This was on convict. Now let's say that in a case, an accused was not convicted by the court, but was rather acquitted. Now, in such a case, what remedy would the victim have, right? So, in that case, a victim would look at Section 378 of CRPC. That is that a victim would be able to appeal that order of acquittal of a lower court in the high court. Right, that's what Section 378 says. There is no specific name given to the section in the CRPC itself. However, the term that I worked on was criminal leave petition. What criminal leave petition is that it is a case type that is used by a lot of high courts, such as Rajasthan, Delhi, Kerala, Orissa, and even J&K. All of these high courts use the case type of CRLP, which is criminal leave petition. However, what is to be noted here is that it is not a common case type that is used by every high court. So you would find different high courts using different case types. So for example, Andhra Pradesh High Court would be using criminal appeal, CRLA. And yes, so there's no common case type for CRLP, but yes, the definition that I worked on was criminal leave petition. And I think that would bring me to the end of this presentation. Thank you.
Thank you, Manas. Thank you, Soumya, Sparsha, and Manas, all of you. Hope you had a good time on this project, and of course, you learned from it. So moving on, now I want to invite one of the esteemed professors who has diligently guided and overseen this project along with us to speak about his experience with the Wiki project. So let us extend a warm welcome to Professor Ankit Kaushik. A little bit about him. He's an assistant professor of legal research and co-coordinator for the Center of Criminology, Criminal Justice and Victimology at Rajiv Gandhi National University of Law, Punjab. And that's all. Over to you, sir.
Okay, thank you so much for that introduction, Harshita. At the outset, I must thank the team at Daksh, Leah, Smita, Bhavya, Harshita, for inviting me to speak at this event, and more importantly, for inviting the Center for Criminology, Criminal Justice and Victimology at Rajiv Gandhi National University of Law, Punjab, to be a part of the Justice Definitions project and the Judicial Data Collaborative as well. I must also take this opportunity to put on record the deep appreciation I have for the team at Daksh and the JDC for successfully conceptualizing and executing this justice definition project as well. The need for this project, it has never been felt more than now, and its importance, it's only bound to increase in the time to come. See, the fact is that for a layperson, the common man, the justice system is quite simply an enigma. It's a leviathan for him, it's a monster for him. It impacts their daily lives, but in ways that they can't really seem to comprehend. I'm reminded of this particular documentary that I had watched a few years back, where the common man had come up with a very interesting acronym for the term Adalat itself. He said that the word Adalat, which means court, it's comprised of 4 letters: the, l, and the. And he said that stands for Ao, which means come here. The stands for Deo, like give me your time, give me your money, give me your resources. L stands for Ladte Raho, like you keep fighting. And The stands for Tabah Ho Jao, that you will end up destroying yourself, right? For me, this acronym that this person came up with, this common person came up with for Adalat, for me, this epitomizes the very perception of what happens when the common man, someone who does not have experience with the criminal justice system, he encounters the justice system for the first time. He comes up against a situation where he ends up being bombarded with legalese, with technicalities that he just can't comprehend. He's bombarded with terms like accused, under trial, convict, bail, bond, remand, custody, plea bargaining, a sample of all of these terms that were presented by the student research associates just now. All of these terms, at the end of the day, they're meaningless to them. And yet, these terms have grave implications for them as well. In most of the cases, by the time that person realizes the importance of this term, it's usually too late for them already, right? So to some extent, it is us lawyers who are to be blamed, right? We are technocrats, right? We take immense pride in throwing about these supposedly heavy terms in the practice of our professions. In doing so, we have built up this aura of exclusivity around the legal profession. We deliberately use these terminologies, sometimes simply to confound the layman. Right? All of these terms can be put in very simple words. Access to justice becomes a casualty, right? It becomes a casualty both advertently and it becomes a casualty inadvertently. As a profession, it seems to work in our favor to keep this domain of justice restricted. But as stakeholders of the justice system, we end up failing our duty to secure access to justice. And this is why when we were given the opportunity to collaborate on this project, my first and last reaction was only to say yes, right? I had told the team at that time that the project is a potential game changer for revolutionizing access to justice by simplifying the jargon that enables scholars, researchers, and lawyers to create and maintain this aura of exclusivity over the subject domain of justice. And I'm sure that this project, as well as the other projects of JDC, they will serve this objective of demystifying the justice system very well. While being a reliable source for litigants and the functionaries of the criminal justice system, this project will also surely benefit the students of law as well. Great care, great caution, great diligence has been taken up to encapsulate the various dimensions of the terminologies which have been taken up in the first set of definitions that have just been uploaded to the Justice Wiki. The pages, they give reference to a very robust set of foundational authorities, official statistics, non-governmental databases, in order to provide the students with additional resources, with additional readings, and the same will, I'm sure, it will help the students in shoring up their knowledge base on the main search term as well as related search terms as well, right? So I must also place on record that the team of student research associates at RGNUL, they have deeply appreciated the experience of working on the project. I completely understand where they're coming from as well. The learning curve that you get when you read up on something in order to simplify it for explanatory purposes, it's simply much steeper than when you learn something when you read only for the purpose of knowledge enhancement, right? And this is precisely why I would definitely encourage more law students and more members of the legal fraternity, legal community, the legal professionals to take up this task of updating and refining the existing definitions, and also to contribute towards the expansion of the definitions project as well, right? So in the end, I would like to congratulate the team at Daksh. I would like to congratulate the team at JDC for the successful launch of this project. I am positive that this project will push the boundaries of legal literacy in this country in an unprecedented manner. And I can assure you that you have CCBs and RGNULs and my personal support and cooperation in this endeavor as well. Right? Thank you. Back to you, Harshita.
Thank you, sir. That was very insightful, and especially the acronym for Adalat. I think we can definitely use that somewhere. So we're already much over time, so I'm just going to keep it short. So thank you, everyone, for joining us here today. We are very excited to hear from you as we have officially launched the wiki page today, and we'll share the website links for you to explore. And as Smita had mentioned before, if you'd like to contribute to the wiki, please fill out the Google form shared in the comment section. We'll also share it through our social media. And in case you want to talk about it, if you have any questions, you can also directly DM us over social media or mail us from our website. We'll coordinate with you. We'll answer your questions if you have anything. Thank you everyone for coming, joining, and for all the presentations that we went through today. And with this, we end today's session. Thank you everyone. Hope you all have a great day.